Hi, everyone. I'm attorney Donna DiMaggio Berger, and this is Take It to the Board, where we speak condo and HOA. My guest today is retired Community Association attorney Marvin Nodiff, whose fiction and nonfiction work has been featured in national publications, magazines, print, and press. Marvin's 8 intriguing fiction novels are the result of his more than 30 years' experience practicing community association law. Readers were first introduced to St. Louis Community Association attorney Joshua Fyler in Marvin's 2002 novel, Special Assessment. By the way, those are 2 of the dirtiest words in community association industry, but we can talk about that later. Following on the success of that first novel, Marvin wrote No Spitting on the Floor in 2011, The Dark Condos in 2014, The Condo Kerfuffle in 2016, HOA Gobsmack in 2017, The Pinball Lawyer in 2019, Magnet for Murder in 2021, and his latest novel, The Great Condo Heist, was just released in April. The themes in these books include a variety of societal challenges, including cybercrime, judicial corruption, surveillance drones, gun violence, populism, the pandemic, and artificial intelligence. And by the way, for people who are frequent listeners of the podcast, you know that we've delved into some of these very topics on the episode before. One constant in Marvin's writing is that both our protagonist, Joshua Fyler, and drones appear in all of his novels. Now, I just finished reading The Pinball Lawyer a few days ago, couldn't put it down. And I also have to mention that Marvin's character of Joshua Fyler is a total chick magnet and a bit of a commitment phobe. So if we have time, we're going to dig into that later. Marvin, welcome to Take It to the Board.
Thanks for the invite, Donna.
So you've written a lot of great books, and I mentioned in the introduction, they all follow the exploits of a young St. Louis Association attorney named Joshua Fyler. I have not read all of your 8 books, although I plan to read more. I'm going to ask you where I go next. But let's focus on The Pinball Lawyer, which you published in 2019. That book was actually sent to me, Marvin, by another podcast guest. I had Neil Johnston on the podcast with Chris Tahn. That episode involved drones. And after the episode, Neil sent me 2 gifts. One was a little mini drone, and the other one was your book, The Pinball Lawyer. And it took a little while, but I started reading it, and I said, I've got to get this guy on the podcast. And then I looked you up. I went to your website. I saw how prolific a writer you were. And what I love is that you've written fiction books. So there's a lot of people in our industry that write books about, association governance and boards and what to expect. And those are all very useful books. But I love that you wrote fiction books. And you would think that, for those of us who do this as a living, why do we want to read a fiction book about it? But I can tell you, it's great to read fiction about what we do. So you've covered a lot of familiar territory in that book, and I want to talk about it today. But let's talk about the association battles you outlined in The Pinball Lawyer. Let's start with the Creve Coeur HOA. So when the book opens, we find that this homeowners association is in the midst of basically a generational fight, right? You've got the board that has decided to specially assess to install a tot lot in the common areas. And now you've got this other group of folks, older folks, the baby boomers, who don't want to pay the special assessment. And they say, why? We're not going to use this. How'd you come up with that? And is it because you did handle generational gaps in your own practice when you were practicing?
Right. This particular HOA, I use as a platform to demonstrate kind of the qualities that an HOA leader, in this case, her name is Caitlin, can implement. And the empathy that she has in dealing with different people, welcoming them in, making them feel a part of the community. And it's her leadership. And she deals with a difficult developer because there's a couple of unbuilt lots. And she's able to negotiate with Joshua Fyler's help, the attorney, negotiate a deal where the developer donates the unfinished lots to the community. Now, what are we going to do with this land? And that's where the tension between the older folks, the baby boomers, and millennials, younger generation, it's the realtors know this community as
stroller land.
Stroller land because of all the kids. I think it's important first to recognize them, to appreciate them, to listen to the parties, because listening is half is half of resolving a dilemma. Listening is half of that. And Caitlin does a good job of that. She's able to win over the vast majority, and that's a victory. Some people will never pay because that's just who they are.
Well, you mentioned empathy as a hallmark of good leadership. Now, you practiced community association law, Marvin, for 30 years or more, correct?
Yes. Yeah.
How many of your boards exhibited empathy and used that leadership style, would you say?
Some.
Some. Okay.
No, I mean,
why do you think there is lack of empathy in community association governance? Because there is. Look, I've been practicing almost as long, and we've both seen it, that there is sometimes a strict adherence to rules or a willingness to shut out conflicting opinions. Why do you think there is a lack of empathy? Particularly because these are your neighbors. It's a living together relationship. What do you think drives that?
The attorney's role and the manager's role really is to work with the board and to identify, I think what makes our practice so much different from other fields of law is that we're dealing, decisions are made by groups of people. We either have a board, which is 3 or 5 or 7 people, or we've got the entire community of homeowners. And so we have lots of personalities, different agendas, and that sort of thing. So the decision-making, a lot of it comes down to kind of the social behavior, the group decision-making process. And it's important for each person on the board, I think, to be recognized. But the attorney's got to also recognize, is this member not participating? He or she is more passive, and the board is dominated by somebody with a very strong will. So you've got to balance that. You've got to recognize that. And some boards just kind of view their role as by God, we're going to make the decisions. And they don't consider the impact on the other members. They don't consider that home ownership is one of the highest values in our society. One attorney gave me some wise advice years ago. It's not how it looks, it's how it lives that counts. And board members don't take that into advantage enough. And they're kind of afraid to have what we call town hall meetings, just their open sessions. They're not open, they're not transparent. And the important thing when you make a decision is you expect that people will comply. If you're increasing assessments, that people will voluntarily pay, that they'll understand, that they'll buy into the concept, that they're getting value for this additional assessment. Boards need to understand that rather than just be dictatorial. I think they need to have more empathy because it is a community. And if you forget that, then you're on a downhill slope.
Listen, human nature is, we know not everybody's a rule follower, right? We also know that sometimes the wrong people get elected to the board. So one of the things I've pondered is, how do the members make an informed decision about who they really should elect, assuming that they're actually, Marvin, even participating and casting a ballot for their directors? How do they decide who's the best person to put in those seats?
That's a dilemma that I like to explore in my novels, because it is so important and it is very random. A lot of people run for the board for the wrong reasons. And I don't have to go into all that. But owners, I think, need to recognize that they all have a stake in the community, and that what you want on the board is someone who will listen and consider the options and listen to the manager's advice, listen to the attorney's advice. He's got to be receptive, not have some preconceived notion of what things ought to be. And very few people I found on boards read the governing documents, read them in terms of understanding how to implement, read them with the task of saying, okay, I'm going to identify here for the board what we must do, what we may do, and what we cannot do, because those are basically the 3 categories. And I can't tell you how many meetings I've had with boards that come in, say, well, we've got this terrible dispute with an owner, and we decided to do this, and now he sued us. So my first question is, can I see the minutes? Let me see the records. And they look down and say, minutes? Well, they're sketchy. They don't have sufficient training to go into that position.
Well, and also it's been my experience, Marvin, that when you get newcomers to the board, there's no onboarding process. Nobody really sits them down and says, okay, Susan, this is your job now, or this is what we've done in the past. Very rare for there to have any sort of, unlike when you're hired in your professional career and there's some sort of onboarding, when you get on these boards, a lot of times it's just, you're just thrown on the board and, nobody sits you down. Nobody talks about, what the expectations are.
No transition, no orientation session. Here are minutes for the last 6 meetings, just for a small example.
So in Florida, we have a mandatory certification requirement for board members. Board members can either sign a form saying they've read it, understand, and will agree to uphold the governing documents, or they can attend a training session, which has been approved by the Division of Florida Condos. Our firm has done hundreds of these each year, these board certification classes. Other law firms do it. I think the management companies may even offer them. We've got the division, the state offers them. So yeah, there is training here in Florida, but every state's different, to your point. And I wanted to talk about every state being different because when I was reading The Pinball Lawyer and Charlie and his gang of baby boomers who said, we're not going to pay this special assessment for the tot lot because we're not going to use it. Joshua, your character, talks about the legal options. What he didn't talk about was simply leaning in foreclosing, which is what we would do in Florida if a special assessment is duly passed, assuming the board had the authority to pass it and they followed all the statutory protocols. Somebody doesn't pay it, even if they don't like what the purpose of the special assessment. The consequence in the state of Florida would be a lien on your home or unit and ultimately foreclosure. Is that not an option in Missouri?
Well, look, Joshua, the attorney, likes to have buy-in, and he could be Machiavellian like anybody, dropping the hammer and starting legal proceedings, starting with a lien. That's always an option based on your governing documents. But he'd rather have voluntary buy-in. It's better to have the assessments paid with a voluntary understanding of here's what it's going for, here's why it's necessary, and paid in full as a voluntary thing, rather than have the tension of a collection action. As far as state law goes, Missouri's a UCA state, not HOA.
So explain that to our listeners.
The statutory authority for liens and priority of liens comes from state statute because condos are a creation of statutory work. HOAs are more deed restriction derived.
So you have no separate HOA act in Missouri?
We don't have an act covering. We don't have an equivalent statute for HOAs. Say, here's the definition of an HOA. Here's the association. Here's what it's comprised of. Here's the board. Here's how they're elected. And all that level of detail and the collection procedures and rights that boards have.
You talked a few minutes ago about getting buy-in and understanding, and I 100% agree with you that when boards are looking, to update their rules. I once had a client come to me. They had a 120-page rule book, 120-page rule book. And I said, the first thing we're going to do is you're going to tell me whether or not any of these rules are still needed. How many of these are still needed? Again, if one was you had to park head in as opposed to back into a parking space. Yeah. What's the rationale? Now, once upon a time, there had been landscaping there. There was a rationale. That landscaping no longer existed. That rule needed to go. But the point you just made, Missouri doesn't have an HOA act. Florida does. We have all different states with all different statutes. I know there's been a push for years to have a uniform common ownership statute, but we're not there yet. Do you think part of the issue, Marvin, is we've got people who, particularly in Florida, a lot of times these are second homes for people, vacation homes, where they may have a condo or home in an HOA elsewhere or in another country. And they come down and it's just a cultural difference because they're doing something different in someplace else with their condo or their home. And so it's very hard for them to understand when they go into a new state with different rules, different statute, different administrative code. Do you think that's part of the hurdle?
That's part of it because condos and HOAs, how they're treated varies a lot state by state. And Florida has one of the highest populations of people who live in community associations. So I understand why your laws are more
robust, a little more robust.
Yeah, robust. It takes a AI to sort them out. But no, I hear stories all the time about people who have gone down to their second home in Florida. And the stories basically go, they get involved in the board. And it's like, well, this is how we did it back home.
Bingo. That's the issue. I mean, I had a realtor at one of my meetings stand up years ago and say, well, the board can't foreclose on homestead property. And she had told a lot of her neighbors that the association could not foreclose. In fact, that was misinformation, because associations in Florida can foreclose for delinquencies, as can banks, regardless if it's the homestead property. So I think a lot of that misinformation does play a role in terms of the challenges boards face and managers face when they're attempting to enforce things.
Yeah. I had one board in the city where a sitting judge was on the board, a real judge. It was on the condo board. So we'd have a meeting, and issue ABC would come up, and I would explain, here's the law, here are your options, here's how I think we should deal with it. And it was all very rational, and I showed the benefits and the downside. And then everybody would turn to the judge, who just wound up 3 board members, and the judge would say like 2 sentences, and then everybody said, well, okay, we'll go with that.
So it's good to be a judge.
Well, not from my standpoint.
I'm sure you do what I do with my boards when they have attorneys or engineers or CPAs serving on the board, to try to tell those directors not to wear 2 hats, that you're wearing the director hat right now. You don't also want to find yourself in the uncomfortable position of being the director on the board and also serving as the de facto association engineer, because if you do that, you've got no safety net. To me, the professional advisors that the board hires, whether it's attorneys like us, engineers, architects, accountants, those are their safety net, bringing in those outside professional advisors to guide them.
Oh, absolutely. Yeah. It's a major mistake, serious mistake, I think, for lawyers and other professionals to get on the board and start giving advice. Having a board and an attorney is fine with me. Their role, however, should be to know the right questions to ask, and to be able to say, this is something we need outside counsel. We need independent counsel to help us, to guide us through this, because it's a serious question. They should have the expertise and knowledge and professionalism to be able to spot an issue that needs outside counsel. And the managers as well. The managers, and I don't want to generalize too much, because some are very bright and they know when to call the lawyer. Others, however, are affected by the need to keep the client, the need to impress the client. So he or she doesn't want to be threatened by an attorney coming in and wants to kind of impress the board with his or her own knowledge. I had a manager once who kept a 3-ring binder of legal opinions from different attorneys on a whole range of stuff. So when a question came to the board, this manager would go through her notebook and find an opinion letter from some other attorney about something else. But she said, well, here's how it goes. And this is like the unauthorized practice of law. Rather than seek an independent opinion about that particular matter, they deferred to the manager, who had all the wrong instincts.
Well, and without the benefit of the framework of decades of case law in Florida, arbitration decisions, the administrative code. And to your point, I'm laughing because I've had the same challenges when it comes to this. Sometimes, Marvin, it's because the board is pressuring the manager. They don't want to pay the lawyer, right? When they pick up the phone and call us or email us, they know they're going to get a charge, because that's what we do. We bill for our time. So if they can kind of pressure the manager to serve as a quasi attorney, they'll do it. But to your point, a lot of times, because our practice is so commoditized and they want to keep costs low, that's what's happening there. And I think it is dangerous. And I have seen some associations, it just happened last week, where they've relied on a manager to give advice about a contract dispute, and it's cost them. And what I tell clients is, listen, if your question starts with, is there liability if, that's a legal question. Mm-hmm. Anything pertaining to liability, it's going to be a legal question. Does Joshua confront that in any of his books?
Yeah. And confronts the question, because if you follow that story to the next step, where the manager is giving what amounts to legal advice to the board, and the board takes that advice And it turns out to be wrong. And now there's serious ramifications. The board's been sued, yada, yada. The manager goes to an attorney. Now the attorney, be it Joshua Fyler, Joshua's been in this situation where he's conflicted because he relies on the manager for a lot of referrals and wants to protect the manager and protect the manager's backside and, get the manager out of the middle of this problem where she's misinformed the board, misadvised the board. So it creates a dilemma down the line.
Let's get back to the HOA battle at Creve Coeur, because we're getting to the point where the drones come in at the park where they're having their ceremony for the new tot lot, and the drones drop paintballs. Some residents are hit with the paint, and then sometime later, Joshua's BMW is hit. His lovely BMW is hit with paintballs. His two lovely dogs are hit with it. I noticed drones play a recurring role in all your novels. So why? Tell us what the fascination with drones is.
Fascination, right? You pulled the word out of my head. Believe it or not, yeah, I write fiction, but there's a lot of research behind the fiction. And on drones, when the FAA, I was fascinated by drones, but when the FAA came out with their draft rulemaking to create this kind of registration system, certification for drone operators back in 2015, I read the entire rulemaking process. Neil and I are probably, Neil Johnston, one of your former guests, and are probably one of the few attorneys who have actually read the entire thing.
But how long? I have to stop you. How long was it?
Oh, it's over 600 pages.
Did you have insomnia? You were reading the entire...
It was fascinating. Questions like, well, federal airspace is down to start with, I think it was 500 feet. 500 feet. And then they lowered it in the final rules 400 feet. And there's this whole discussion about why they lowered it. And then who has jurisdiction over the first 200 feet and so on. I mean, it was, and whether you had to have line of sight and blinking lights and all that stuff. What fascinates me, and I turned it into an article for the Fordham Urban Law Journal on drones and privacy, because there's nothing in the federal rules that said you can't have a drone fly close to a home where there's occupants. So that produced a whole article. I co-authored it with a professor at UMass, Amherst, Hillary Farber. That was back in 2017 or so. So I've done a lot of research on drones. And what's fascinating is that they have such a promise to deliver good things. And drones are like your cell phone. The basic function is, for a cell phone, you make calls and you receive calls, you have conversations, you communicate. They become great tools because of all the apps you can add onto them. The same with drones. Drones just fly from here to there. But when you start adding sensing devices and imaging capability to them and cameras and everything, they are terrific. So they can do a whole range of things. Just think about it, a simple thing, a board needing to evaluate gutters and the roof surface on a taller building. Well, the old way is to get a ladder and then somebody's spending a whole lot of time and risk of safety. When you can have a drone fly over and give you some great images for less risk.
Well, same thing if we have Mrs. Jones and we believe that she may have flammable materials on her 12-story balcony, but she's not going to let us in the unit to go check it out. So a drone could be useful in that regard. I mean, you use surveillance drones. Some of my communities use drones for inspection, for architectural control inspection purposes.
Yeah, I have that scenario in one of my books where the board uses surveillance drone to look for violations. And of course, that's turns into, how you can misuse a drone as well.
Of course, in the pinball lawyer, the drones were not friendly. They weren't dropping care packages. They were splattering people with paint. Yeah,
well, I think it was in Central America or South America, some public official, there was an attempt on his life using a drone. So I've researched that as well. What technology is available off the shelf to turn the drone into a weapon.
Those four children in Colombia that just survived 40 days in the jungle, their plane crashed. I'm
Incredible.
pretty sure that is incredible. I'm pretty sure I read that drones had dropped. The military had used drones to drop care packages, and the kids actually found one.
Wow.
And
Yeah.
So to your point that they can be useful, you're right.
Oh, absolutely. Yeah. And I think Neil Johnson references, or one of your guests references, in emergency situations where the power goes out, there could be temporary cell functioning with drones. They can look for, in terms of disaster, they can look for survivors and evaluate flood conditions, for example. They're extremely useful. At the same time, in the wrong hands, they can be weaponized.
Well, I want to talk about the role of Hannah Hancock, the reporter who's covering the Creve Coeur debacle. And she covers a lot of the different things we're going to talk about. She seems to be in the book, Marvin, subtly on Joshua's side. Okay, subtly. But, listen, I've been interviewed extensively over my career. I was interviewed in connection with the Champlain Towers collapse. I had a plane fly into one of my buildings, one of those charter planes. I've had a car drive in. I mean, lots of things happen in these communities. So I've had extensive experience being interviewed by the media. I will tell you, my experience has not always been positive because some reporters, they've got that story written before they even come to you. They know the angle they want. By the way, they know, what they're going to cut out of what you're saying to make it fit what the angle is. What do you tell, and I know Hannah plays an important role in your book, so I know you've got experience with media. How trusting do you think volunteer directors should be, and even their counsel, when it comes to the media and its role in reporting HOA issues?
The spokesperson needs to be careful and wary. But really, the last thing you want to say is no comment.
Because, Why?
Because it feeds the message that you're hiding something. And it's better to say, we're looking into it. I don't know yet. We're just starting our inquiry. We're figuring out, it's better to be open, available and open. And I mean, you're right. When one of the unfortunate things, and this has come up for decades in our practice field, is that community associations get a bad rap in the media. If it bleeds, it leads. And that's the type of thing that we have to battle, not in a negative sense, but we have to deal with, because some reporters are looking for that story. They want to find a villain. They want to find blood. And that's a story. I carry this relationship, I think, that community association, in particular Joshua, the attorney, have with reporters into the next couple of books. And I mean, this is spanning like 4 years. The book that follows Pinball is called Magnet for Murder, where we get into more of the journalism.
That book dealt with the pandemic, correct?
It's about issues that come up during the pandemic and the role of attorneys in that. And also significantly the role of journalism, because I personally am very concerned about the loss of independent local community journalism. So we get into these issues and we introduce a character named Phoebe as an investigative reporter who is, very familiar. She's done the research, and all the reports about community associations are that they're crazy and they do crazy things. And so she considers Joshua to be an untrustworthy investigative collaborator. They're thrown into kind of a forced marriage in working through COVID-related issues like insurance scams that come up and a whole series of suspicious murders. So they're thrown in as two people who didn't know each other previously, strong egos. They're both proud of their profession and they don't trust each other. And then we see how that relationship works through as they work on this discovery, investigation. So that's
okay. That's my next read, because I've had, for most of my career, I had a very, very positive relationship with reporters who were looking, I think, to give fair and balanced pictures, stories of what happens, But when Champlain Towers hit, it was crazy down here. And you had reporters, all sorts of tricks, all sorts of misreporting, miscommunications, you name it. It was very unfortunate behavior, rushes to judgment, again, writing the stories before it was even written. And as we sit here 2 years later, most of the things they said have not even been proven. So that's going to be my next book, because is there some scarring after dealing with the media that I dealt with then? Because previously it had been a very positive relationship, but yeah, I'm going to be honest. I was a little scarred and taken back by some of the journalistic behavior I saw.
Yeah. Well, journalists want to get, they want to get their byline. And
you said it. If it bleeds, it leads. Well, and I know that there were journalists in that looking for a Pulitzer.
Well, Surfside made an enormous impression on me, and just trying to understand what happened and why it happened, and to translate some of those lessons into fiction. And I look at my fiction, Donna, as a way to inform more people about how community associations work, to kind of push back this negative image, because I want to have examples of how they do good things and how people are happy. Yeah, there's controversy and there's problems, but we overcome them. Here's how. So I try to create information about how community associations work. And given that, like a fourth of all Americans live in some form of condo or HOA or co-op, there's a big market out there to deal with. And now so informing, and I want to do it in an entertaining way. I've had lots of comments from readers saying, I recognize that character. She's on my board. I recognize that manager. That person is in our community. So it's resonating. It's resonating with the audience out there.
Well, and I love that you do it with humor too. You use these quirky names, right? You've got Snapper for the office manager. You've got the law firm of Boondoggle, what is it? Braggadocio do Boondoggle?
Braggadocio.
Flapdoodle and Doofus, or BFD.
BFD, that's where I was headed.
BFD, you've got Snapper, the office manager. You've got a state rep named Leroy Blowhard. Chippy Kimbrough is Joshua's nemesis. But you do it with humor. I love that. I love that, because I think you're right. I will tell you, listen, whenever I've had challenging things in my life, I read. That to me is my therapy. If I'm going through a challenging time, I may pick up and read. I've got a little, you're looking at me in my office, but I've got a little book of Winston Churchill here. Oh. And I feel like if Churchill could do it, we're probably going to get through this. So books really, really help. And I love that you're normalizing a lot of this. I want to talk about let's turn to the condo issue, because we talked about Creve Coeur and what their issue was. The condo in your book, Pinball Lawyer, is Artemis Condo. And they're doing something that so many of my clients try to do, which is pass an amendment, right? And their amendment they want to pass is they want to put a cap on the amount of leases permitted. And I loved Joshua's argument about why, when he was asked about this, why are they trying to do this? They're trying to do this because the feeling is if you get to a certain point and you have more rentals than people living there as their homes, you've got a complete change in the culture of the community. Hence the reason to potentially, pass this rental cap. Of course, this does not sit well with the investment owners at Artemis Condo, and they want to squash it. The board in your book tries to mediate this dispute, to resolve it through mediation. In your practice, Marvin, how successful have mediations been in terms of, putting out small skirmishes, preventing them from turning into full-blown conflagrations?
My read is that attorneys get the worst of the worst cases. Maybe it's 2% of the worst 10%, because managers and boards are able to resolve a lot of the internal disputes. Maybe we're jolted in terms of because we get the worst of the worst cases, the most difficult, the most complex. And I mean, I've had my experience with serial filers, owners who had on their computers, they had, form petitions and they just file them. And so we've seen a lot of that. So it's really the lawyer's job first to try and resolve the dispute before it goes further. And it can go to mediation, and it's been successful from my standpoint, my experience, as long as the board members have an understanding of how to deal with the process of mediation, that, you can have a position or you can have an interest. Forget the position. What you want is something that is good for your community. And I told boards who say, we need to have consensus on this. I said, no, you don't. You need to have alignment. The question is not, do you approve 100% of this, but can you reach a resolution that you can live with? That's alignment. And that just tilts the table in a whole different way, a whole different perspective. And that kind of way of dealing with disputes, I found, is successful.
To that point, though, because I had a retired judge on the podcast, and he's now a mediator. He talked about how important preparation is for the mediation and how important it is to bring the right people to the mediation table. So if you're bringing a board member who's completely entrenched, that may not be the right pick. Would you agree, for the mediation? Yeah.
It's up to the attorney to, and that's what's so different about our practice, is that, decisions are made by multiple people, and they all have the personalities, agendas. Some are passive, some are dominant. Some want to win at any cost, by God. And you've got to filter those people out.
Sometimes the director with the worst communication style is the one who is spearheading all of the communications. That's been one of my challenges. You also, in the book, you deal with another condo, and that's the electric fan condominium, and it's leaking windows. You deal with construction defects. Again, I'm reading this book over the last couple of days, and I'm like, well, Marvin did it again. That's another issue I'm dealing with right now. Yep, did it again. So what intrigued me about your inclusion of the construction defects case in your book is the fact that our Florida legislature, Marvin, just passed a bill that has drastically reduced our statute of repose, which is the longest statute of limitations in Florida to be able to bring a claim for a latent defect. And for our listeners, a latent defect is a defect that is not readily apparent to the naked eye, okay? So the statute of repose in Florida used to be 15 years when you found that hidden defect to bring a claim. This last bill reduced it down to 7, and it also changed the triggering of the clock from the latest of a series of events to the earliest, which could include a temporary certificate of occupancy. And in Florida, associations are not able, they don't have standing to bring a construction defects case until they've transitioned from developer control. So ostensibly, with this new law, in some HOAs, by the time they turn over 7 years later, the clock's already run for any hidden defects. My question to you, because I know you've got a lot of government interwoven into your books, okay? And we'll get into that. Caitlin's running for mayor. You're dealing with legislation. How are developers still convincing state legislators to chip away at consumer rights when it comes to construction defects?
I can, really speak from the standpoint of my home state, my adopted state. I grew up in Arizona, but I've lived here for 40 years. I worked in state government long before I went to law school. I worked for about 8 or 10 years. I started in the state auditor's office. Interesting, because I had a poli-sci background. I was hired because I could read and write. And we started doing, this is a major innovation. My boss, Kit Bond, started doing performance auditing, not just financial. So we asked the questions, what are you supposed to do? How well are you doing it? How effectively, how efficiently are you carrying out your job? Whether it's inspecting widget manufacturers or hog farmers, And my job, really, I met with the field examiners when they came in after looking at all the records. And I sat down with them and said, what do you guys find? And so they gave me their findings. And I'd sit down and say, what are you trying to say here? What's the big what's the big story? And one of them told me after an examination of the Division of Finance that it was easier to open a bank in Missouri than it is to get a loan. So my job was to write the report for public view, write the report into plain English. And it was a great spot to see how government worked. And I didn't know at the time how much those lessons would translate when I became a lawyer and this type of law, because dealing with boards is much the same, because the factors, the stakeholders, lobbyists from, trying to influence and so I looked at state government. I had a lot of interaction with the legislature over the 6 or 8 years that I worked in government. I worked in the governor's office and the Department of Natural Resources. So I had a lot of interaction with the legislature, and I can look and compare what we have now. Now we have term limits, and the lobbyists, if you look at kind of institutions that affect policy, lobbyists for major interests are important. They become more important because of term limits. Now you have this institutional history in lobbyists as opposed to the legislators.
Why do you think the lobbyists have become more important because of term limits?
Because it's easier for them to control through contributions and controlling the information. Who do you think drafts a lot of the bills that the legislature looks at?
You're absolutely correct. I used to be a registered lobbyist in Florida. And my only client was a group called CALL, which is our Community Association Leadership Lobby. And it was non-paying, but it was comprised of all the different associations throughout Florida. So it would go up there and try to educate our legislators about what it meant to, how do these associations even operate? What do they need? How do they, what are the challenges? And the first thing I would ask is, how many of you have actually lived, when I would testify in front of a committee, how many of you live in a condo or HOA? Maybe one or two hands would go up in a committee of a dozen. How many of you have served on the board? No hands. So there was a complete disconnect in many cases. And this was years ago. I could never lobby now, Marvin. When I see what's going on, I could never lobby. But you're right, in as much as the legislators often don't know what's in their own bills to any great extent. They're relying upon the lobbyist to, give them some context. They're not subject matter experts on most of any of the bills they're sponsoring. Right.
They really lack an independent source of information and evaluation of legislation. And that tension, I think, raises a critical issue for community association leaders, and to the extent that we, as, I don't want to say an industry, but, homeowner interests can be represented fairly and effectively in state legislatures. On one hand, you've got large lobbyists who make contributions to candidates, and it creates. Now, I've seen this come up in different legislative action committees across the country. Do we want to form a PAC and raise money so that we can kind of even the scale here of influencing or having access to legislators? And, in one of my books, I put this quote: on election day, would you rather have $1 million or 1 million votes?
What's the answer?
I look at this and say, we'll never outraise the kind of money that special interests have. We need to impress people with the number of people we have, the number of voters that we have. That's where I am on that whole issue.
Well, let's jump into the issue of preemption, because in your book, there is a bill pending that would preempt regulation, I believe, of drones and short-term rentals like Airbnb. And we're, again, living that down here in Florida. Our governor right now is set to sign a bill which would preempt even landlord-tenant rights. So I'm speaking to you in Fort Lauderdale, Florida. There's a Broward County ordinance which says that if you condo or HOA board, you turn down a potential tenant, you have to give a reason as to why you would. If this bill signs, potentially that means you can't have an ordinance that says that. There seems to be a grab in terms of this preemption trend that everything that the state knows best. And I just had Vice Mayor Ray Martin on from the city of Lauderdale, and we talked about it. And he said, if this continues and it's taken to its illogical extreme, why do you even need local government anymore? The state will just control everything. Is this a problem in Missouri as well? And have you seen it elsewhere? I mean, I know you do your research for your books.
Yeah, Missouri is the preemption leader, I'm sure, in the country. We,
Really?
state preempts everything.
What's the motive for that? Why? They're control freaks?
A motive? Well, the motive is that certain interests want to have their interests protected. And it's easier to influence the state legislature for reasons we discussed a few minutes ago than a whole bunch of local governments, because you have one target and they're down in the same room versus hundreds of thousands of municipal and county level governments. So it's easier. I mean, on the drone thing, they tried that in Missouri a couple of years ago to preempt local governments. And they want to change in zoning, in the state zoning law, that would declare short-term rentals as residential, period. They would be defined as residential. Well, really? I mean, there's a commercial operation and it's a zoning thing, and zoning forever has been a thing of local control. So that one definition would basically preempt local governments. It didn't pass, but that's an example of preemption.
But it's out there. And speaking from my experience, once the idea is out there, they tend to revisit it. How many counties do you have, Marvin, in Missouri?
113 plus St. Louis City.
You have 113 counties. In Florida, we have 67 counties. I mean, go around the country. Do we really think that a state in these large and even the small states, that they know what's best in all of these counties, and then even drill down even further in all of their cities?
No, there's just two different. There are two, TOO, too many differences. I think in Florida and probably Missouri as well, there are really some sharp differences between urban areas and rural areas.
Yeah.
And one size does not fit all. And zoning is a particular issue where that's proven to be true. One size does not fit all. It's zoning is important to have a say in the quality of life for people, where you separate different uses into different areas. And that's a local matter because you want to protect communities and let them thrive by having effective zoning. And that's where short-term rentals come in and so many other things. So it's really harmful. And to look at condo and HOA problems from the perspective of Jeff City and say, well, one size fits all. If they're, if the legislature is dominated, and they are dominated by representatives from smaller counties, rural counties, that don't have the kinds of high-rise condos that the urban areas have, then you really need to allow the urban areas to deal with those problems. And Surfside comes to mind. To what extent should we have inspections? Should it be driven by local government or state law? And reserves and funding and disclosure of all that. Those are important issues because we have older building stock in the urban areas.
Well, it's funny you mentioned that, because in the immediate aftermath of Champlain Towers, the legislature concluded its regular session and didn't pass a single safety reform. Of course, there was a huge outcry saying, are you kidding me? We just had this catastrophe and you guys ended session without anything. They went back in special session. They did pass a bill that called for massive reforms. We only had 2 counties, Marvin, in Florida that required building certifications when buildings reached their 40 and 50 year anniversaries. Those were the only, Miami-Dade and Broward. In the aftermath of Surfside, and that legislation passed in the special session, now it was a requirement for all 67 counties. And they also passed a requirement mandating funding of reserves. Because as you know, so many older buildings for decades just decided to kick the ball further down the field and not fund reserves. But this last session, the glitch bill that was passed, SB 154, that bill kind of goes back and says to counties, the local authority can set deadlines. They can give you more time, they can give you less time. So to your point, we hear about it all the time in a state as diverse as Florida, culturally, demographically. Sometimes when the state comes down and really wants to throw the book at boards, you've got a board in Jacksonville or Fort Walton Beach saying that's a Miami condo board or HOA problem. That has no relevance whatsoever. And as a matter of fact, you're putting handcuffs on us, and you're not only are you solving a problem that doesn't exist for us, you're creating a new problem.
Mm-hmm.
So to your point, I agree. Again, I talked about the names. I talked about Joshua's nemesis in the book is Chippy Kimbrough IV, and he works at BFD. What's the largest? And I get the feeling that it's kind of a David versus Goliath battle you're setting up here. And I'm a partner here at Becker. We are probably considered the 800-pound gorilla in the Florida market, and we're in other states as well. So I have to tell you, I've got to ask you, what's the largest law firm you've ever worked for? How many attorneys?
Well, I think I mentioned that I went to law school like 10 years after I graduated college. So at the ripe age of 33 or 35 or so, when I got out of law school, I knew that I wasn't going to be attractive to a large firm, regardless of grades, just my age. And second, I really didn't want to. I had been a grunt in many of my life experiences prior to that. So the reason I went to law school is I realized that state government was fun, but it was not a profession, it was not a career. And so I wanted that kind of stability and certainty, besides getting to know how important the law was during those 10 years. So I started my own firm. So in answer to your question, one.
I knew you were going to say that. But I started out and I worked at a little boutique firm. It was a family-owned firm. I was the only attorney who was not a family member, but they treated me very well. So I've been at a 6-lawyer firm. And now I think we're not a huge firm, but I think we're at about 150 attorneys. So they'd probably be considered large. To me, it boils down to the relationship with your particular attorney. So I don't know it's the size of the firm. And I think that's what you were getting at in your book with BFD. I think it was not the size of the firm. It was the culture of the firm, which seemed fairly cutthroat.
Yeah, I enjoy the conflict for a David and Goliath scenario, because I think it's something that readers will grasp. It's something that's of interest to me. And I've been up against the large firms on construction defects, on all kinds of cases, not little ones, but big cases. I had a case down in Branson, Missouri, where there was the biggest firm in St. Louis was on the other side. So I've been around that track, and it's, they'll load you up with all kinds of paperwork and discovery, and like that, they can try to overwhelm you. So I think it's not just tempting, but it's a real dilemma, because you want to even the scale in terms of representation for condo associations and HOAs.
Well, let me talk to you about even in the scale. When you were actively representing associations, did you ever come up against people representing themselves pro se? For instance, sometimes when we go to covenant enforcement actions, when you're enforcing against a violation, the violator will represent himself or herself without benefit of counsel. Did that ever occur?
Oh, sure. Even in collection cases, we've had that.
So in those cases, Marvin, you were the BFD.
Oh, yeah. I mean, it's
you were the Goliath in those cases.
It's easy just looking at the association as a party in a lawsuit against an individual. It's easy and tempting to portray the association as the big bad organization, the corporation that's oppressing us, overwhelming us.
And yet sometimes they're the victim. And it is, the perception is out there, but sometimes it's actually the big bad association that's in the more vulnerable position.
Right. Yeah. And that's circling back to our discussion about journalism and reporters. That's a point that will take some work, I think, with journalists to get that perspective that associations are not the big bad oppressive players in this.
So in a couple of your books, particularly in Pinball Lawyer, Marvin, you tackle the issue of judicial corruption, right? In the book, the judge, by the way, the judge's name, I recognize that name, not as a judge, but as a member of a very esteemed member of CCAL. Just a coincidence, I'm sure. But he refuses to recuse himself despite having a relationship with the large law firm BFD. Has that been an experience in when you practiced, that you had concerns about judicial corruption?
That's an extreme example, and sometimes in fiction you have to use extreme examples to make a point. In the day-to-day practice, now in Missouri, the system of appointing judges has been around since the 1940s, when Missouri was really a pioneer in devising a system where the governor appoints judges, but from a panel of possible nominees who are named through the bar system. So they're all qualified candidates. However, that applies to the urban areas. City of St. Louis, for example. Outstate, it's a whole different thing where judges are elected. Same in Illinois. Judges are elected. So I have to wonder, when I have opposing counsel next to me and I'm in front of a judge in another county, did my opponent give a campaign contribution to this guy? Are they going to have lunch after this hearing? So that's, that definitely tilts the scale for us. And it, we almost have to look at hiring local counsel when we have a big case outstate.
I mean, this is such a broader topic in terms of judicial integrity. We're seeing it play out on the national stage. So I look forward to reading future books and seeing how you continue to tackle that issue. I want to talk about artificial intelligence, because I've been really following ChatGPT. I've been following Elon Musk saying, and the other, Silicon Valley moguls saying that this is going to be the destruction of humanity. And yet they still developed all the technology for it. BFD has, in your novel, a computer named Clifford, which Joshua first believes is just some genius researcher locked away in a dungeon somewhere that's turning out all these great briefs for them. Turns out Clifford is, in fact, artificial intelligence, and he kind of feeds it a little virus along the lines of the Independence Day plot with Jeff Goldblum. So I recently asked ChatGPT, Marvin, how do we get good people to serve on a homeowners association board? And within 60 seconds, actually spat out probably 8 paragraphs, bullet points, really good. Sent it to my marketing department, said, can you believe this? Can you believe this? Like, this could actually form the basis for something. It's such a great tie-in with what you wrote that book back in 2019. We're in 2023. And now we're talking about ChatGPT. I can just imagine the wheels turning in your head about where this is going. My question to you is, first of all, what are your thoughts overall about artificial intelligence? Is it going to improve association operations, or could it go off the rails?
Believe it or not, in my most recent book, I do have an episode with AI in a different setting from pinball. And actually read a book to try and get more understanding. I do try to do research when I do things that I'm not familiar with. And at the end of the book, I saw, okay, AI can be extremely helpful for associations and managers in sorting massive amounts of data. And I use the example of going through all your delinquent accounts for the past 5 years or something, to get an idea of why people are delinquent, and to break that down into different, age. Is it an age thing? Is it a family thing? Is it people living alone or older people on fixed incomes? What's the best way to tackle our delinquency issue? And we use AI to sort through massive data for a large community. However, it's not so useful for things like landscape violations, where it calls for judgment, because AI doesn't have human judgment. They can give you a result, but they have no idea. AI has no idea if the result is good or bad.
Not yet, Marvin. We'll see.
Well, that takes a human touch, and that's really the dilemma, I think, for the future of AI is bringing in a human touch into the final decision making. So I do have an episode in my new book on AI.
So everyone's talking about which professions is AI going to render obsolete? I actually thought about, could you have an online manager who can, but you just mentioned the judgment calls that have to be made. Could you have a Clifford that really, as association attorneys or as attorneys, I don't know that we need to fear being rendered obsolete by AI, but what are your thoughts?
I envision a new division down at the city civil courts building called Division 99. Okay, so you're a homeowner and you're maybe a serial filer. So you go down with your petition, you can file it in Division 99, and then your opponent has 30 days to file an answer. And AI makes the decision because you can tap all these court cases and render a decision, and you'll never have to talk to a judge.
How far out do you think we are from this possibility?
Not far.
All right. We'll see. I wanted to read a quote from Pinball Lawyer that I really liked. At one point, the office manager Snapper, and for people, you read the book, you'll understand why she's called Snapper. She says to Joshua, "You're like the silver ball in a pinball machine, ricocheting off flippers and bumpers. Is it a game of skill or chance? How can you practice law when you're pinballing from one crisis to the next? Do you feel that all legal practice areas fit that description, or our practice area of community association law in particular fits that?"
No, I love the quote because it's so real. It is real. It also may be surreal. And I think it reflects practice in our field. Community association lawyers have to know a lot about a lot of different fields of practice. Everything from easements to fair housing and all of that. And on top of that,
labor law, contracts, even sometimes criminal law, you name it.
There's more than a dozen fields that we have to be extremely familiar with. And because we're going from one issue to the next, as we move from one file or one case to another. And on top of that is the complexity of the client. We talked about this a few minutes ago, that clients it's group decision-making. And a lot of, half of my time was spent being a social worker, trying to deal with people and people problems, not legal. You have to understand the people problems before you can deal with the legal problems. So that makes it even more complex. And yeah, sometimes you feel like a pinball. And I love that quote because it just, it reflects. That's why I named the book The Pinball Lawyer. Because
I love it. And it definitely resonated with me. But how did you find time to write when you were a practicing attorney? I love to write. I've written a fiction book, nothing to do with associations. It's more historical fiction. Never had time to actually wrap it up. But how did you find time to write?
It kind of begs the question of why I started to write, and then I found the time to do it. Some major decisions just come because opportunity or challenge is plunked at your doorstep that you weren't expecting. I hadn't thought about writing fiction. There's one particular manager who I'd known for years, and she'd call up and tell me about this problem, and I'd see if I need to intervene and get involved. So one day she called, and it was late in the afternoon, and she was telling me about this, this disgruntled owner and all kinds of complaints, and this is really complicated, and the board is upset, and on and on. And at the end of this lament, she said, this stuff is really crazy. Someone should write a book. And I thought about that, and I thought, that's a dare. I'm being dared. And so I paused that, and in the weeks after that, I looked into it and wondered, of the fiction that's out there, nobody's really setting stories in community associations. I have a vast array of material to work with. I have all kinds of fun issues that are interesting. If I can figure out a plot that's both entertaining and has mystery and has some romance in it, then that's a big challenge. So that's what I set out to do. And while I was practicing, the only time I had to compartmentalize. You put your files in your head, you put them in a box and put them away. And 10:30, 11 o'clock at night, I'd start and I worked for a couple of hours. That's where I found the time.
You feel like writing is your life's purpose?
It's hard to say. It's satisfying in the sense that I think there's something of value. I mentioned earlier, one of the things I want to do is inform the broad general public about the kinds of issues and the community and the lifestyle that's involved in community association living. Inform. It's another way of educating. To me, that's really a high priority. And I want to do it in an entertaining way with wit and plot twists and that sort of thing.
You make a really good point, because people learn in all different modalities. Some people, it's visual. Just show me a video or a webinar, I'm good. Others want to, delve into more scholarly articles. But I think there is a huge benefit to reading about this in an entertaining fiction novel, which is why I was so excited to have you on the podcast, because we're in our second season. We've had a lot of people have not found anybody who does what you do. And I think it's really cool. So now that you're no longer practicing actively, though, where are you drawing your inspiration for plots and characters?
Oh, because I keep up with my colleagues across the country. And, it's not like I'm just kind of inspiring these crazy things. Read the headlines and ask the question, what if this happens? I like to put kind of typical boards. I like to have colorful characters, memorable characters, but put them into unusual circumstances. We have to deal with emerging technology. My first book talked about cybercrime, and it wound up being years ahead of computer hacking that has occurred. And I've talked about the issues of drones and the potential for that, or the downside of that, and all kinds of things that I look at, new issues that boards will wind up dealing with.
You're curious. That's it. You're curious. And from that curiosity, these plots and characters come. Has anybody ever reached out to you and said, Marvin, I know that's me you wrote about in that book?
Oh, yeah. Yeah.
Are they flattered or horrified?
Mistaken, mostly.
It's not them. A lot of times they're seeing themselves in the character.
It's not a particular person, but there's certainly the model of that type of person, a personality, for example.
Is Joshua based on you? Fess up.
Fess up?
Yeah. And by the way, I have to say, I said it in the intro, all these very attractive women seem to be want his attention, really into him. He's a commitment phobe. Is this based on you at some point?
Joshua is tall. He's handsome. He's got charm. He speaks fluently. He's got charm. Did I mention that?
You did?
Yeah. And so, and he's attractive to women. So it's definitely not me.
All right. I'm going to let you off the hook on that one. And I've taken up so much of your time. I did want to say, when we were talking prior to this episode, we both have daughters in the entertainment industry. So my daughter, Lauren, is out in LA. She's working for a large talent agency. Your daughter, Monica, is in New York City. She's doing marketing and training for people in the theater business. Is there any chance one of your books is going to make it to a screen or stage anytime soon?
Yes. Some great authors were not discovered until much later in their careers. So I'm patient.
Well, maybe this podcast episode will help. So tell people where they can find all these wonderful books.
They can find them in the CAI bookstore online, and some of them are with Amazon. But any member of CAI, of course, will get the membership level in terms of the pricing. So that's first place to go. And
what about your website? Don't you have a website that talks about all of your books?
It's my name, marvinnodiff.com.
And Nodif is Nodiff, marvinnodiff.com. Marvin, thank you so much. I am going to read, what's the latest one out?
The new book, the newest book, came out in April, and it's entitled The Great Condo Heist.
Okay. All right. Maybe we can get you back on to talk about once I read a few of the other ones.
Love to. It's been fun, Donna. Thanks so much.
Thank you so much. Thank you for joining us today. Don't forget to follow and rate us on your favorite podcast platform, or visit takeittotheboard.com for more ways to connect.